another aspect, as I just mentioned in my introduction, that there is a need to delineate between IHL and the legal framework governing terrorism, because there is a lot of confusion around. In particular, there is a lot of confusion because many think that IHL does not really address the phenomenon of terrorism in situation of armed conflict. And this is not the case. Yes, of course, IHL does not provide any definition of terrorism, in particular in the Geneva Convention or in the additional protocols. But IHL prohibits clearly most of the acts that are designated as terrorist acts under counterterrorism legal framework, be it at domestic or international level. I think in particular the prohibition under IHL to attack against civilians, which is based on the principle of distinction, which is a cornerstone of IHL. IHL prohibits also indiscriminate attacks, such as sniping or bombing in urban areas. This is clearly prohibited by IHL. Hostage taking. And you see these actions are generally the kind of act carried out by non-state armed groups designated as terrorists. So yes, IHL really provides a framework for terrorism because it prohibits most of the acts that are designated under counterterrorism legal framework as terrorist acts. And by the way, those prohibitions under IHL are applicable not only in international armed conflict, but also in non-international armed conflict, are of a customary law nature, and therefore also binding upon non-state armed groups. I just say that IHL does not provide a definition. This does not mean that IHL is silent on the issue of terrorism, because IHL, for instance, prohibits acts of terrorism. It's Article 33 of the Fourth Geneva Convention. It also prohibits measures of terrorism, Article 4 of the Additional Protocol 2 applicable to non-international armed conflict. IHL, and in that case, these prohibitions are really just geared towards the situation, covering situation in which acts of terrorism are inflicted by belligerents, irrespective of their nature, against person and group of persons under their control in a situation of international and non-international armed conflict. The rules, IHL rules on the conduct of hostilities, are also covering acts of terrorism. Probably you are aware of the famous Article 51, paragraph 2 of the Additional Protocol 1 covering international armed conflict, but also a similar rule applicable in non-international armed conflict. It's Article 13, paragraph 2 of the Additional Protocol 2, which clearly prohibits in situation of hostilities acts whose objective is to spread terror among the civilian population. And this is covering situation of conduct of hostility. So you see, just to say very quickly, that IHL, yes, it does provide a very strong legal framework for addressing the issue linked to the fight against terrorism. This framework is applicable not only in international but also in non-international armed conflict, is binding upon clearly all belligerents, and violation of this legal framework entails the individual responsibility of their perpetrators, not only at domestic but also at international level. So you see, for those that are saying that IHL does not provide an adequate framework, it's pretty clear that it's not true. Yes, IHL permits clearly to pose and to clearly lay out a framework for those acts of terrorism committed in situation of armed conflict. So you see there is some, in a way, some common grounds existing when it comes to prohibition between IHL and the legal framework governing terrorism. It's not to say that everything is similar in these two legal frameworks. It's not the case, because still IHL and the legal framework governing terrorism are very different because they have different objectives, different rationale, and different structure. So there is still huge differences between IHL and the legal framework governing terrorism. To name just the most important one, to give you some example, in situation of armed conflict and in legal terms, in a way, in legal terms, situation of armed conflict addresses acts that are lawful and acts that are unlawful. We all know that the objective of armed conflict is to overcome the enemy. So in this respect, it is authorized under IHL to attack each other military objective and to attack persons that would not benefit from the protection granted by IHL to the civilian population. So you see IHL regulate both lawful acts of war, but it also regulates unlawful acts of war, in particular acts directed against the civilian population. And you don't find this kind of dichotomy in the legal framework governing counterterrorism, because it is all made of prohibition. So there is no permissive rules when it comes to action carried out by non-state armed groups designated as terrorists within the framework of the counterterrorism legislation. This is one of the fundamental distinctions. The second fundamental distinction that it is that under international humanitarian law, all belligerents, including non-state armed groups that have been designated as terrorists, they have equal rights and duties under international humanitarian law, which is not the case under domestic law, by the way. And the objective of this principle is really to make sure that IHL objective will be fulfilled, which is to ensure the equal protection of all victims of armed conflict, irrespective of the places where they find themselves, irrespective of the side on which they find themselves in situation of armed conflict involving non-state armed group designated as terrorists. So you see the main difference. The problem that even if these differences still exist, there is still some overlap and some contradiction between IHL and the legal framework governing terrorism. There is overlap simply because even if IHL provides a strong legal framework, even if IHL prohibits acts of terrorism and even clearly qualifies them as war crimes, there is nothing under the law that would prohibit states to, in parallel, consider the same acts as being also terrorist acts under their own domestic legislation or within the framework of international instruments governing counterterrorism. So there is this risk of overlaps. Even more problematic is the existence of contradiction between the legal framework governing terrorism and IHL. In particular, because in instruments governing counterterrorism, some of the acts that are considered as lawful or at least not prohibited under IHL, basically attacking military objective of the enemy, would be considered as unlawful and as crimes under the legal framework governing terrorism. So you see the potential overlap. And this is an issue for us for three reasons. First of all, this contradiction, it clearly exemplifies conflict of norm at the international law level. And I can tell you the international law level on IHL and on the legal framework governing counterterrorism is already very complex. So by having this contradiction, you add a level of complexity to an already very complex situation. So it creates conflict of norms at international level. The second problem is that it adds an unnecessary layer of criminalization by criminalizing this kind of action, simply because IHL, as I just told you, already criminalized these acts of terrorism in situation of armed conflict, but also because most of the time, and 99%, the domestic law of the state involved would still prohibit action carried out and any kind of action carried out by non-state armed groups designated as terrorists. So the domestic legal framework would continue to apply. And why it will continue to apply and to restrain the action of non-state armed groups and would give the possibility to state to prosecute those guys, is simply because most of the time the fight against non-state armed groups designated as terrorists is within a framework of non-international armed conflict. And in non-international armed conflict, you have no combatant privilege and no combatant immunity. Therefore, it's not unnecessary to have another layer of criminalization in international instruments governing counterterrorism. And the last point, and I will just terminate by this, it's also problematic because by considering that any act carried out by non-state armed groups designated as terrorists, including lawful acts of war, this criminalization would clearly discourage IHL compliance by those non-state armed groups involved in situation of non-international armed conflicts. All motivation of those groups is likely to erode if, irrespective of what they do, including lawful act of war, everything is considered as criminalized. So what would be the incentive for them to respect a soldier they had captured in detention? It's easier for them not to get the burden of the capture and to kill the soldier. They said, in any case, even if I provide him with the right condition of detention, this will be considered as unlawful, but also potentially as a terrorist act. So what would be the incentive for those groups to comply with IHL? In addition, this will even render more difficult the implementation of Article 6, Paragraph 5 of the AP2, which provide for amnesties for those having participating in hostilities in situation of non-international armed conflict and having respected IHL. So by qualifying acts as terrorist acts, it's almost impossible to activate clearly this provision, which is essential for peace process and reconciliation efforts. That's why very clearly we thought it's important not to criminalize lawful acts of war carried out by non-state actors, irrespective of their designation. And I will just conclude here. I would say that for many, to hear that, in a way, IHL may be respected by some non-state armed groups designated as terrorists, it goes a bit the trend, actually, because we have all, when we are just discussing so-called terrorist group, which clearly reject the values underlying IHL and respect the core, disrespect, the core respect for IHL. That's a reality. But we need to bring also another element of this reality that it's at the tip of the iceberg. We are still involved, and that's the majority of the case, in situation of much more classic non-international armed conflict with classic non-state armed groups with which, yes, it is possible to have a discussion on having more compliance on their side on, for humanitarian law. That's why, in our view, it's very important that the legal framework governing counterterrorism will still give us organizations just like the ICRC, just like the NRC, clearly to reach out non-state armed groups to engage them on the issue of IHL compliance.
With regards to terrorism, how do you see IHL, grave breaches and terrorism converge? Particularly, I'm looking at Article 147 of Geneva Convention 4. So what's your take on this?
On the criminalization aspect, and just to say that my areas of expertise do not include criminal law, international criminal law. What I can only say to you that if you look at the provision of IHL dealing with the grave breaches in the Geneva Convention, but also the provision of the additional protocols, Protocol 1 in particular, dealing with the violation of IHL and qualifying them as war crimes. And if you look also of many of the actions that are criminalized under the Rome Statute under Article 8, you will find that the most important prohibition of IHL, in particular action directed against civilian and civilian objects, are prohibited under international humanitarian law and most of the time qualified as war crimes for the purposes of international humanitarian law. And if you look, there is always a kind of corresponding crimes against the civilian population, which can be found also in instruments dealing with terrorism at international level. That's where, for action directed against civilian and civilian population, there is a convergence between the legal framework governing counterterrorism and IHL. Where the problem lies, and I just mentioned it, it's under the law governing counterterrorism. It also criminalizes actions that are considered as being lawful under international humanitarian law, at least not prohibited, meaning the action directed against military objective at large. And that's where we have a problem. But when it comes to criminalizing the core prohibition, and when it comes to prohibition of action against civilian and civilian object, there is a real convergence between IHL and the legal framework governing terrorism.
Are there tangible examples of states applying willingly IHL to counterterrorism operations?
For your question of the kind of example, I would say that I'm a bit uncomfortable simply because we are actually discussing with some states on the necessity to apply IHL in a framework that they consider as being only a fight against terrorism without labeling it a situation of armed conflict. Mainly very often for policy reasons, for reasons linked to granting legitimacy to non-state actors, and here I want really to underline that under international humanitarian law, there is specific provision, I think in particular Article 3 of the Geneva Convention, which clearly states that the applicability of IHL will have no bearing on the legal status of the parties involved. So once again, to detach the policy aspect of the fight from the factual aspect, which in our view may trigger IHL applicability. And there is also another issue for not applying IHL is the so-called demonization of the adversary. And considering that because of the very specific features of the adversary, because in itself the adversary normally in the mind of some states does not respect IHL and the basic values underpinning IHL may not apply or may apply differently to their action against non-state actors designated as terrorists. That's the famous expression, the exceptionalism, which is actually ongoing when it comes to legal discourse surrounding the fight against terrorism. Otherwise, there is plenty of examples in the past where states, having designated non-state armed groups they were fighting against as terrorists. And you know, even sometimes if the qualification does not really match the legal reality, but most of the time in situation of non-international armed conflict, the government fighting non-state armed groups, they always tend to designate their opponents internally as terrorist armed group. So yes, there is actually some example, but there is also other example. We are struggling with some states in order to ensure that irrespective of the designation given to a non-state armed groups, IHL, because of the facts on the ground, will apply to their action.
The first observation on the lack of convergence you have been talking about when it comes to military targets. I mean, often bombings labeled terrorist make use of perfidious tactics. So in which case they are actually outlawed by IHL. So for that type of attack on a military target, there shouldn't be a lack of convergence. And it's, as far as I know, in concrete reality, a very relevant point. The second observation, I make my students, I like to make them aware of the protection caveats, if you could call them that way, in Security Council resolutions. So this caveat, which many of you may be aware of, which does require states to respect IHL, international human rights law, and also refugee law, because there it is also very relevant and increasingly so. In many Security Council resolutions, it says so that states have to comply in their counter-terrorism measures with these three bodies of law. And then to end with a quote from Security Council Resolution 2178 on foreign terrorist fighters, I think it's a very important, pertinent statement made by the Security Council. Let me read it to you all. It says, underscoring that respect for human rights and the rule of law are an essential part of successful counterterrorism measures. So, and noting that failure to comply with these obligations is one of the factors contributing to increased radicalization and foster a sense of impunity.
It's true that what we are just aiming at is making sure that lawful acts of war are not criminalized under counterterrorism instruments. This would go against the integrity of IHL under the basic principle of international humanitarian law and the very essence of humanitarian law, which is that parties to an armed conflict are entitled to attack each other's objective. Of course, the means sometimes that may be used in order to reach this legitimate objective can raise question vis-à-vis the conformity with the law. You were referring to perfidy. And I can tell you sometimes it's not easy to determine whether an action against a legitimate military objective carried out by a non-state armed group fall also under the prohibition of perfidy. And can we consider that an EID, which is hidden behind a vehicle, is it perfidy when the objective is only to target military personnel when passing through this point? It's something that is not easy to determine under international humanitarian law. We at the legal division, we are struggling with this issue. But I can tell you very often, attacks against military objectives are also conducted in compliance with international humanitarian law. There is plenty of non-state armed groups that are carrying out, of course, certain acts that are violation of IHL, but we must also give them the credit that very often, and much more than we think, the non-state armed groups, even those designated as terrorists, carried out military action in compliance with IHL from the beginning until the end of the operation. And don't forget that under IHL, they are not required to wear a uniform, but only to distinguish themselves at the time of the attack. So, and that's where it's very difficult to distinguish between a lawful action from the starting point, the planification of the action, until its realization against a legitimate military objective, and we have to look at this. But of course, and that's what we do in the field, when we think that attacks against military objectives, so attacks that are lawful or not prohibited under IHL, are conducting by using means and methods of warfare that are in violation with IHL, it's something that we address with the non-state armed groups with which we can interact in the field. It's pretty clear from all sides.
Now I'm thinking, for instance, of suicide bombers and using children, for instance, in that context, or suicide bombers wearing civilian clothing. These are not lawful under IHL. So I'm just saying that there is not a lack of convergence across the board. There are situations where IHL...
and the big problem is that if you look at the instruments governing counterterrorism, what they have in mind is it's not the measures and the action taken with a view to commit an action, but they are looking at the result of the action. And if you look at the international or regional convention governing counterterrorism, what are prohibited, it's action against public agents, which would include also clearly action against soldiers, which are legitimate and lawful under IHL, but would become unlawful under this counterterrorism instrument. And that's where we have some contradiction between IHL and the city legal framework. And in our view, one of the way, and for us the only way to try to avoid having this contradiction is to make sure that in counterterrorism instrument there would be a provision that would deal with the relationship existing between IHL and the counterterrorism instrument. Because most of the time, counterterrorism instruments are also applicable in situations of armed conflict. They have a very broad scope of application, which includes clearly a situation of armed conflict. And most of the counterterrorism instruments, they have this clause. The problem is the formulation of this clause. And we are actually discussing with some states within the framework of the drafting process of the UN Comprehensive Convention on International Terrorism, which is actually in a stalemate. And one of the main reasons for these instruments not to be accepted and drafted finally by the states, it's exactly the clause dealing with the relationship between IHL and the Comprehensive Convention on International Terrorism. And the position of the ICRC is that such a clause should in no way adversely impact the integrity of IHL, and we want to make sure that by means of these clauses, lawful acts of war will not be prohibited under CT instrument, while we think that other acts that are unlawful under IHL can be also addressed by these counterterrorism instruments. So the big problem here that the states have the tendency to have a very broad interpretation of this clause and to say, irrespective of the nature of their action under IHL, it should be criminalized. And that's why the interpretation of this switch clause mainly excludes from the scope of the CT instrument action carried out by state armed forces. Whereas states, of course, they want to criminalize even lawful action carried out by non-state armed groups. And that's where we have a problem, because here you have an asymmetry, as you just mentioned, and it creates a kind of unbalance now, while under international humanitarian law, one of the core principles is equality of belligerent, equality of the rights and duties of the belligerent.